And I want people to stop shooting from the hip, especially a guy called Rob Sudi, who I believe is a guy that's had a head-on collision with a cobweb, seems to come out and be an expert on everything. But if he was to take the time and go and have a look at the rules and the Bankruptcy Act, you must perform and undertake personal service. I have refiled back into the federal court now, saved up my money, and I'm challenging it within my confinements, and I will win it. There is no question about that.
The full bench of the Federal Court in Culleton v Baldwin Nominees Party Limited, 2017, appealing the sequestration order made in Baldwin Nominees Party Limited v Culleton, 2016, at 103.
The issue raised by the appellant on the appeal was whether he had been served personally with a creditor's petition. The respondent accepted that a respondent to a creditor's petition had to be served personally, and that the appellant in this case, although served by email and mail in mid to late October 2016, had not been served personally with the creditor's petition. The respondent relied on Rule 10.11 of the Federal Court Rules, which provides that upon a respondent taking certain steps, filing an address for service, defence, or affidavit, or appearing before the court, he or she is taken to have been served personally. The appellant filed a notice of appearance and grounds of opposition to the petition in about mid-November 2016, and affidavits between early to mid-December 2016. He appeared before the court on the 19th of December, 2016. The rules in Rule 1.03 provide that the other rules of court apply to any proceeding to which the Act applies except to the extent that there is inconsistency. There is no inconsistency between any rule in the rules and Rule 10.11 of the Federal Court Rules. Any issue concerning personal service has been overcome by the operation of Rule 10.11 of the Federal Court Rules. We reject the appellant's first submission.
In Culleton v Baldwin Nominees Party Limited, 2017, the High Court dismissed Rodney's application for an extension of a previous stay of the orders, and he subsequently discontinued his application for special leave. Finally, Rodney commenced fresh proceedings in the federal court in Culleton v Baldwin Nominees Party Limited, 2018, seeking, amongst other things, an order setting aside and annulling the sequestration order. The proceedings were dismissed summarily. In April 2019, Rodney was convicted of an offence against the Bankruptcy Act, that he failed to make out and file with the official receiver a statement of his affairs and furnish a copy of the statement to the trustee. He sought to appeal against his conviction in Culleton v Australian Financial Security Authority, 2021, on grounds that the court had no jurisdiction, and that the sequestration order was invalid on several other grounds, including the usual 1973 Queen of Australia royal title arguments. Leave to appeal on each ground was refused and the appeal was dismissed.
Freeman delusion, the organised pseudo-legal commercial argument in Australia.